Welcome to Employment Law This Week. I'm George Whipple. Our top story, the Department of Labor takes a final step towards new overtime thresholds. The rules, which could go into effect as early as this summer, will end overtime exemption status for millions of workers and cost employers as much as $250 million this year. The DOL recently submitted proposed FLSA regulations to the Office of Management and Budget, taking the final step before the rules go into effect. Marc Mandelman tells us how employers can prepare for the new regulations.
In advance of the new regulations becoming effective, employers should be immediately consulting with counsel to set up wage and hour audits to identify all exempt employees who earn less than $50,000 to evaluate how to implement the new regulations with respect to that group of employees, whether or not to give them a salary increase or to allow them to become overtime eligible. Employers may also want to work with counsel to identify other potential misclassification risks to determine whether the change in the rules is an opportunity to reclassify employees while mitigating the risk of sparking additional wage and hour litigation.
The DOL has also published its controversial final rule around labor relations consultants. The so-called Persuader Rule requires employers to disclose when they hire a consultant to help fight attempts at unionization. But the rule as written is potentially much broader and could require employers to disclose information about a wide range of consultants and others who they rely on for training and communication. The Supreme Court eases class certification standards in a case against Tyson Foods. In Iowa, a group of Tyson employees brought a hybrid class and collective action for unpaid overtime, spent changing clothes and walking to their work area. An expert determined the average amount of time spent on these activities, and the employees relied on those averages to get class certified and to prove liability and damages. On appeal, Tyson argued that employees should never have been grouped into a single class, because each employee took different amounts of time for the unpaid activities. But the Supreme Court ruled this representative sample could be used to establish class-wide liability, and the case will move forward in the district court. The Second Circuit says an HR director can be considered an employer. A worker at the Culinary Institute of America alleged that an HR director wrongly denied her request for family medical leave to care for her two sons. A New York district court dismissed the employee's FMLA claim against the HR director, ruling that an individual manager did not qualify as an employer. The Second Circuit disagreed, ruling that the economic reality test used under the Fair Labor Standards Act also applies under the FMLA. The court found that, under this test, the HR director could be considered an employer and held liable for any violation of the FMLA. OSHA releases its final rules for whistleblowers under the Consumer Financial Protection Act of 2010. The CFPA is a portion of the Dodd-Frank Act that protects workers involved in consumer financial products and services. OSHA's new rules establish procedures and timelines for retaliation complaints under the CFPA. This is the latest in a series of new standards from OSHA expanding whistleblower protections. Finally, it's time for our tip of the week. Victoria Richter is here with advice on the new executive order on pay transparency.
The most recent restriction on an employer's ability to keep pay confidential is Executive Order 13665, which went into effect January 11th and applies to federal contractors. The basic provisions: employers cannot require employees to keep their pay confidential. They cannot discharge or otherwise discriminate against an employee for discussing, disclosing, or asking about their compensation or that of other employees. In-house counsel need to really do a careful review of all documentation concerning pay and confidentiality. You need to look at all agreements, offer letters, retention letters, annual compensation statements. You also want to be taking a look at your policies, especially compensation policies, confidentiality policies, and even EEO policies, to make sure that they have the required language and comply with the executive order.
Thanks, Victoria. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.